You know all about it. Just about anyone can buy a gun in the United States, well, except for some people. Felons, most immigrants, domestic violence, misdemeanants, traitors, whatever. There's a lot more than meets the eye going on here, and it covers a lot more people than you might think. Today we're going to talk about the history of felonies and gun rights, the worst part about the Heller decision, and just how all of this works together. So we know about 922G1, the federal laundry list of people who aren't allowed to possess a firearm that has been involved in interstate commerce, of course. Many believe it's always been like this. They think that all the way up to the founding of our nation, that there were loads of people who couldn't have guns. But in reality, that's not quite true. In fact, it wasn't until 1961 that felonies in and of themselves became relevant at all to the question of gun ownership, and it wasn't until 1992 that the loss of gun rights became permanent on a federal level. In that intervening time, what constituted a felony, the most serious type of crime in our legal system, bloated like a beached whale. Today, just as many Americans have serious criminal records as we have college degrees. That's not something to be proud of, and I wouldn't be so quick to blame the people with the records either. In the situation we have now, completely nonviolent and frankly boring conduct can lead to a permanent loss of your civil rights. There's been plenty of litigation on this, but the Supreme Court has refused to step in. This seriously affects the lives of a great many people, and I think it's a miscarriage of justice. To get an idea of how bonkers things are, here are a few examples of cases I've seen. In 1989, Larry Hatfield fudged his employment records to get some extra money from the Railroad Retirement Board. He later sued for his ability to own a gun and lost. The Supreme Court declined to hear his case last year. In 2004, Ricky Cantor sold therapeutic shoe inserts that were not quite up to Medicare standards, and he said they were Medicare compliant. He was found guilty of a felony, later sued for his ability to keep a gun, and lost. The Supreme Court declined to hear his case in 2019. In the early 2000s, Levon Roundtree missed 2 child support payments. 18 years later, he's sued for his right to have a gun and lost in Wisconsin Supreme Court. His case is currently on appeal to the United States Supreme Court. In all of these instances, individuals were convicted of statutory felonies, some of which not serving a single day in jail, and all of them had spent over a decade crime-free. Yet still, they were permanently stripped of the right to keep and bear arms. Could this really be consistent with our Constitution? Some of the judges in the courts of appeal that heard these cases made the claim that the Supreme Court referred to felons losing their right to arms as presumptively lawful. Well, if that were true, it would be a hell of a climb for these nonviolent people to get their rights restored. But did the Supreme Court really say that? The language these courts and many courts refer to when upholding various restrictive gun laws around the country is taken from an explanatory sentence in the middle of D.C. v. Heller's 157-page penumbra. The oft-quoted passage goes as follows. Nothing, in our opinion, should be taken to cast doubt on long-standing prohibitions on the possession of firearms by felons and the mentally ill. The lower courts refer to these prohibitions as presumptively lawful, citing Heller. But where do they get that presumptively lawful idea? Well, from a footnote in that same sentence. The footnote reads, "We identify these presumptively lawful regulatory measures only as examples. Our list does not purport to be exhaustive." The thing you have to understand here to figure out what's going on is the difference between a holding and dicta in a court decision. A holding is the black-letter legal determination that sets binding precedent. Dicta, on the other hand, are explanatory comments that lack precedential value. The language identifying prohibitions on felons was in the middle of a paragraph which was simply setting the tone and scope of the decision on page 57 of the opinion. In point of fact, these people who cite this conveniently leave out the fact that the Heller decision didn't actually confirm any gun laws as constitutionally valid, but rather said that long-standing historical justifications for those laws, if those justifications exist, would be sure to surface in future litigation. Now, this misunderstanding is one reason why Second Amendment litigation is such a challenge. It's no secret that some federal courts are in nigh-on open rebellion with the Second Amendment, following guidance from anti-gun scholars to narrow the scope of the Second Amendment from below. The Supreme Court precedent we do have on the Second Amendment tells us that gun laws within the history and tradition of the United States may be constitutional. So how deep does felon prohibition go? Naturally, if it's within the text history and tradition, we'd be imagining that it'd go back quite a long way, right? Well, what if I told you the felon prohibition we have now, if it were a person, would be a millennial? Let's take a quick look back through the history of gun possession laws in the United States. To start with, I'll give away some of the ending. There is no relevant historical justification for gun prohibitions aside from disarming obviously dangerous individuals. It makes sense, as one observer wrote, the colonists in America were the greatest weapon-using people of that epoch in the world. Everywhere in colonial America, the gun was more abundant than the tool. Even under English rule, disarmament laws were designed only to keep weapons away from people who were seen as posing a dangerous threat to the public. Many of these laws were discriminatory and overbroad, and thus manifestly unconstitutional by the later ratified Second Amendment, but even so, they were always specifically intended to prevent danger rather than punish mail fraud. For example, a 1656 New York law forbid the admission of any Indian with a gun into any houses so as to prevent such dangers of isolated murders and assassinations. Of course, these laws were horrible and discriminatory, and before I start hearing it in the comments, let me address one glaring issue right here up front. There were, in the colonial and founding era, disarmament laws targeting Black Americans and others who were then, horrifically, considered subhuman by virtue of their race or national origin. The original drafts of our founding documents were intended to be emancipatory, which would have solved many of these problems, but the grim political reality of the time kept many thousands upon thousands of Americans in literal and metaphorical chains. This includes restricting their right to arms. The due process clauses should have prevented this, but again, miscarriages of justice by political pressure prevented that from happening for an embarrassing amount of time. With that out of the way, let's keep going with the laws not based on an individual's race. Some states passed laws in the Revolutionary War era which disarmed loyalists who were opposed to the liberty and independence of American states on the grounds that they would be dangerous and attempt to install foreign rule. After the Revolutionary War, Samuel Adams opposed ratifying the Constitution without a Declaration of Rights, one of which being to ensure, and I quote, "the people of the United States who are peaceable not be prevented from keeping their own arms." Peaceable, of course, means nonviolent, and nonviolence is a very different thing from law-abiding. Even in the founding era, if you lost your rights, you could generally regain them by posting a bond to ensure peaceable behavior. Again, even when people were disarmed for serious concern of danger, the disarmament was limited until he or she finds such sureties of the peace and good behavior. Some other jurisdictions restored gun rights when an individual could prove his friendliness to the liberal cause. As a pretty wild example, in 1786, Shays' Rebellion saw armed bands attack courthouses and federal buildings, leading up to a substantial military confrontation. Many of the Shayites, rather than being executed for treason, were deprived of their civil rights, including a 3-year prohibition on bearing arms. That's right, in the founding era, people who committed the capital offense of treason had their arms rights restored in just 3 years. Compared to now, when catching a lobster that's too small means you lose the right to arms for your life. We didn't see many more laws affecting this until the Prohibition era, which we've talked about many times before on this channel. As we know, clear as day now, people get a little upset when their government uses violent thugs to make sure nobody drinks any booze except them. So things got violent. In this era, we started seeing state laws disarming people who were convicted of crimes of violence. Again, most of the time with the ability to have their rights restored. The Federal Firearms Act of 1938, which is the basis of many of the modern gun laws we have to deal with now, originally took arms from those only convicted of a crime of violence. The original crimes that were supposed to subject an individual to disarmament were limited to murder, rape, kidnapping, and burglary. It wasn't until 1961 that this was amended to concern felonies, with the words crime of violence being replaced with for a crime punishable by more than 1 year in prison. Even then, Congress quickly added a relief valve by enabling individuals to petition for the restoration of their rights. This part of the law is still there, by the way, but the federal government has refused to provide funding to the Rights Restoration Program since 1992. In justifying this decision, no consideration was made for the rights of individuals or for the insane scope of crimes that have gotten felony treatment, but rather for cost. Indeed, it was the opinion of the ATF that the money spent in investigating and acting upon applications for relief would be better spent by the ATF in fighting violent crime. Fighting violent crime, of course, being a thing the ATF has no idea how to do. So the Supreme Court has said that those laws embedded in the text of the Constitution and the history and tradition of the United States can pass muster. What does that mean for felon disenfranchisement now? Well, back in the day, felonies were serious offenses, the kind of stuff committed by people you wouldn't want to go camping with. Even so, the word felony wasn't terribly prevalent when it came to disarmament, but rather a propensity for violence and danger. Then in the 60s, it shifted to felonies. In the time period surrounding this and leading up to now, what constitutes a felony has expanded faster than you would on an all-cake diet. For example, in 2013, a man from my nation of Florida was charged with the felony of polluting to harm humans, animals, plants, etc. after he released a dozen heart-shaped balloons to impress his sweetheart. The Lacey Act resulted in felony treatment for a lot of heinous crimes, such as getting wood from sketchy sources, catching an undersized lobster, for packaging a lobster in a plastic bag instead of a cardboard box, and for depositing funds into a bank. I don't know about you, but nothing about violating those laws indicate anything about the ability to safely own and operate a firearm. This is only a tiny sample of how insane our overcriminalization problem is. I recommend you guys check out, there's a lot of great books on this, such as An Illustrated Guide to How to Become a Federal Criminal. You can check out the Twitter account Crime a Day. And also, Harvey Silvergate has written a book where he estimates that the average American commits 3 felonies a day without ever realizing it. You can find affiliate links to these great books down in the description. Another shining example, of course, is America's drug war, which the US government has been losing to drugs for over 4 decades now. The simple possession of many drugs carries felonious consequences, yet you know how many people are using drugs. The right to keep and bear arms is about the right to direct one's bodily autonomy, to prevent you from being helpless should a wrongdoer decide to try to destroy your life. There's only one simple question here. Does violating a statutory felony, such as failing to pay child support or putting a lobster in a bag, justify you forever losing that ability to secure your body? I certainly think not, and here's to hoping that the Supreme Court has the stones to do its job, to agree to hear the Roundtree case, and to finally set the record straight. That you don't lose your human rights for releasing balloons, being a deadbeat, bagging a lobster, or selling the wrong shoes. Well, that's it for today, guys. Let me say I really appreciate you watching and subscribing. It makes a huge difference. If you want to support me more than that, I started up a Patreon and a Subscribe Star. I got benefits like a patron-only podcast, Discord, surely more to come. This kind of support will help enable me to make more content more regularly, something I'd really love to be able to do. There's also a link to the new and improved Fuddbusters apparel, which you can see here. We've got stickers and, of course, the magic ATF ball. All of these links are down in the description. All of these wonderful products that I don't think I'd be able to live without. Thank you all so much for watching to the end and for your support. I'll see you next time, or if you become a patron or subscribe star, I'll be happy to chat with you on the Discord. Remember, the anti-side has been working long and hard, passing laws, trying to make more. Anything more than minimum compliance is self-regulation. Y'all take care.